What is this? Other production. It's item 2, Malad. I had mentioned in the morning, Malad. Item 2 may be taken up for a minute. The file of item 2, which is Writ Petition 1913 of 2024. 19? I can just explain in 2 minutes, Malad. Yes. Item 2's file may be kindly considered. Because this is regarding recruitment of primary teachers in government schools, Milords. And the requirement, one of the requirements is diploma in elementary education, d.el.ed. As a one-time scheme, Milords, the government of India had permitted certain candidates diploma in elementary education, d.el.ed. D.e.l.ed. Diploma in elementary education. D.e.l.ed. D.e.l.ed. Diploma in elementary education. Yes. As per NCT, NCTE, the National Council for Teachers Education, the prescribed limit is 24 months. That's National Institute of Open Schooling. Which period? From 2017 to 19, the government of India permitted certain candidates to complete this course within a period of 18 months. Yes. The question of whether these 24 months is equivalent to 18 months came before the Honorable Supreme Court in a judgment arising out of Uttarakhand. On 28/11/2023, the Honorable Supreme Court set aside the Uttarakhand High Court judgment saying that these courses cannot be treated equivalent for all purposes. Relying upon that judgment, my lords, I am the one who has done these 18 months course. I was considered ineligible for an advertisement issued by the government of Assam, and on 2nd January 2024, the government of Assam issued a notification saying that because there is an Honorable Supreme Court judgment which says that both these courses are not equivalent, hence we will not consider it. There were multiple review petitions and applications filed before the Honorable Supreme Court, where government of Assam was also a party to that. And the Honorable Supreme Court on 10/12/24 clarified that both these courses are equivalent for all purposes. On 10/12/24, not just clarified, my lords, the Honorable Supreme Court also said that this clarification will be effective from the original date of the judgment, which is 28/11/23. That is also mentioned in the Honorable Supreme Court's order. Now, the present advertisement which is in question is of December 23, which is after the Honorable Supreme Court's clarification. And 2nd January 24 is the notification by which I have been removed. Thereafter, my lords, once the clarification came, most of the states, almost 9 states, have already applied the clarification. One example I want to show where Honorable Supreme Court itself applied its own judgment. The lords would now kindly have with me for a minute those 2 orders. One is the clarification order. Second is how Honorable Supreme Court applied its own order by a subsequent order, saying that whoever has done 18 months diploma will be eligible to participate in the state's recruitment process. The matter came up before my lords.
Recruitment process, even if it's advertisement is prior to the judgment of
yes, my lords.
Is it so?
Is it so? That is the point. Yes. My lords may now for a minute kindly see, if my lords have item 2, Writ Petition 191.
Yes, please come.
Yes, kindly come.
1913.
Yes, kindly come to page 106 for a minute. That is the advertisement. I wanted to show the date, my lords. Advertisement is page at 106. The date on top right is mentioned.
26 December 2023.
26 judgment is of 28/11/23. 28/11/23. Which is Supreme Court judgment is prior. The advertisement is later. The judgment is 1 month prior to this.
Yes, yes.
Then kindly come a page back to 105, my lords. Where is the notification which removes me? Which is the improved notification in the writ petition. Kindly have page 105. May I read, my lords?
This is under challenge.
This is under challenge. This is under challenge. The second paragraph is important. The advertisements were prepared and published in compliance with the order passed by the Honorable Supreme Court dated so-and-so 28/11/23, which is very important, in Civil Appeal so-and-so, wherein it is stated that the qualification of 18-month diploma in elementary education acquired from so-and-so is no longer a valid qualification to be eligible for fresh recruitment to the post of teachers. This is the notification under challenge. Now kindly have notes the clarification order, which is in my additional affidavit. In the very same volume, there is an additional affidavit that I have filed, which starts from page 336. Well, 336, the additional affidavit starts. I'm sorry.
Come to relevant page.
Yes, I'm showing the relevant page in the additional affidavit.
Yes.
My lords may kindly have page 347, which is the Honorable Supreme Court's order. 347 is the Honorable Supreme Court's order. And my lords would kindly mark the fifth application number, which is 42144 of 24. 42144 of 24 is the application. I'm sorry, 347. 347, and the fifth application number, which is 42144, is a application where Government of Assam respond number 4. Then kindly come to the operative part, which is at next page, 348. Para 3 and 4 are very, very important, if I may read. However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10th August 2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional level. Two conditions they say. 10th August 2017, I should have been in job. All the petitioners were in job. And I have completed the course from NIOS in that period. That is the condition stipulated. Fourth is very, very important, my lord. Exactly the question that fell from my lord. Needless to state that the clarification will be effective from the date of pronouncement of the judgment under review. The judgment under review is dated 28/11/23. And this, my lord, is then applied. So this is passed by a bench of Justice Gawai and Justice Mishra, my lord. And then this is applied for one of the states by Honorable Supreme Court, which my lord would now see at page 350. See how the Honorable Supreme Court is applying its own order. The earlier was a different bench passed by Justice Gawai. Page 350 is another bench headed by Justice Roy. Kindly see, my lords, what has been applied in that matter. 350, the order starts. I had the fortune to assist the Honorable Supreme Court in this matter, my lords, at page 350. The relevant is at 351. And I am seeking the exactly same order what the Honorable Supreme Court has passed for Bihar. The same very order I am seeking. Kindly see 351 now. May I read, my lord? The the first paragraph is important. Since the Bihar Public Service Commission had issued an advertisement on 7th February 24, which is prior to clarification after the judgment, for recruitment of primary school teachers class so-and-so, the applicant seek participation in the counselling process, which is to commence from so-and-so. It is submitted that around 36,000 candidates are in fray and the present application is made on behalf of 215 aspirants. Para 3 is again very important. Miss so-and-so, learned senior counsel appearing for NCT, and Mr. so-and-so appearing for NIOS support the stand. They are supporting the applicants.
Who are you reading?
I'm sorry, my lord. This is 351. 350, the order starts where the Honorable Supreme Court, by an order dated 20th December, different bench, Justice Roy applies the order passed in clarification. So 20th December is the application, my lords, and the relevant is at 351. My lords have it?
Yes, yes.
So I am reading the second paragraph, my lords, which is on top of the page. Since the Bihar Public Service Commission had issued an advertisement on 7th February 24, here the advertisement is of December 23, after November's judgment, for recruitment of primary school teachers, the applicants seek participation in the counselling process, which is to commence from so-and-so. It is submitted that around 36,000 candidates are in the fray, and present application is made on behalf of around 215 aspirants. Then para 3, they basically say NCT and NIOS is supporting my stand. Para 4, they reproduce the clarification order. So on 20th December, Honorable Supreme Court is reproducing the order to say that to avoid any confusion, we again clarify that the 18 months is equivalent. Therefore, my lords, at para 6, they say, in the meantime, we deem it appropriate to allow the participation of the applicants in the counselling process being conducted by the Bihar Public Service Commission. The outcome of the counselling process, so far as the applicants are concerned, be kept confidential. And this, my lords, is once again reiterated at page 355. So there is a series of orders where every court is saying that please, both of them are equivalent. Therefore, you cannot deny any opportunity to the applicants herein who have completed this 18-month course. And the recent one, again, my lords, is a detailed judgment by the Honorable Supreme Court in the Uttarakhand matter. 3 days back we had argued, my lords, and a real judgment is coming. Can I just tender the copy?
So why don't we approach the Honorable Supreme Court?
Well, the answer to that is this, my lords. In those matters, my lords, the matter was sub judice before Honorable Supreme Court. What the orders that have been passed, if my lord would see, these are orders passed in the transfer petition. The point that I am trying to urge today, my lords, is this matter came up on 18th March, and my lord were kind enough to give us a patient hearing on that day, and also directed that is the Pathward matter. The state sought an adjournment that day. 2 hours later, my lords, 2 hours later, they have taken out a list of verification of the regular candidates who have done a diploma in 2 years, saying that verification has to start from yesterday for 4,100 candidates and will continue for the next 10 days. Question that I put to myself is, lords, would I not expect a fair participation in this entire process when the law is decided in my favor, when all courts are holding in my favor, and not once but repeatedly? In fact, my lords, the division bench of this honorable court has also held, I will show that order, my lords, that we are eligible and equivalent, but to participate in the same very process as a regular candidate would do. So if my lord would have for a minute this recent judgment, because this was argued this 5 days back, my lord, can I just show 2 paragraphs from this? My lord would kindly have.
Are you a fresh candidate?
I am a fresh candidate. I had applied, my lord, and I'm not being called for verification.
You are not in the job.
I'm not in a job. As of now, I'm not in a job, my lord. But as per the Supreme Court order, on 10th August 2017, I was in job. I have produced proof to that effect. The Honorable Supreme Court's order requires 2 things. 1, you should have been in job as on 10th August 2017 when you applied for this course. I was in job. I produced my proof to for all these petitioners. We have to produce proof. The second thing is that
why you are not in the job now?
Malus, I am not. Some of us may be in private jobs. Some of us, the schools have been closed. This is regarding government jobs.
Job is it would mean the employment in the government service, not just because otherwise everyone is on the job.
Yes, Malot, so kindly has this exact point came up before the Honorable Supreme Court. Just have 1 paragraph and that will be clear. Malot, just 1 paragraph my lords would have.
This is a Pathward matter.
This is a Pathward matter, but I have this only 1 second, if you don't mind. This Pathward matter, I am not even arguing on that.
When it is likely to be? When is this fixed?
It is fixed for 8th of April, my lord. But we have moved an IA yesterday because of this notification which has come out 2 days back after the hearing, 2 hours after the hearing.
Where is that notification?
Yes, now kindly have the IA for a minute.
So are you a press candidate or are you a diplomatic candidate?
No, there is 2 things, my lords. I have applied.
What is the advertisement is for?
The advertisement is for government teachers in the state cadre, and the post is there. The vacancy is about 5,500, and I want to be appointed as a government teacher, subject to fulfillment of other eligibility criteria. There are 2 sets of people who have applied for this.
So in that case, there is no question of you are in employment.
Indeed. If I have applied, I am absolutely not in a state government job as of now. Therefore, I have applied. Or else, what was the need to apply? So, hence, my lords, the Honorable Supreme Court said that as on 10th August 2017, you should. Yes.
That's the relevance.
But I must be fair, therefore,
whether, as per the Supreme Court, whether you are eligible or not.
Yes.
That you just show it. That's
yes.
While who are employment.
Yes.
Whether you are that point of time you are employed or not, forget about it.
Yes.
So you will have to go along with the context of the advertisement will have to.
Yes. In terms of the advertisement,
it doesn't. They didn't ask for the permanent candidate.
No. They have said that you should have
appointment only.
I'm sorry.
Fresh appointment only.
Yes, fresh recruitment. They have said that you should have a valid diploma. I am saying my diploma is valid.
Yes.
As simple as that. That is the short point. They are, as per this notification which I read, they say my diploma is not valid, therefore I will not consider it.
Your challenge is basically page 105.
105, which has now been overturned by Honorable Supreme Court.
I am handicapped by 2 things. One, the morning it was mentioned, I did not have my file today with me. I don't have the reputation. I have no documents with me. Secondly, the learned AG is appearing the matter. The lead matter was, if I'm not wrong, 447 of 2024, 477, which went up in appeal when the interim order was rejected. Disposing of the appeal, Honorable Division Bench has given a direction that the interim order of not declaring the results of the appellants of petitioners will remain in force till the end of the litigation. That remains. That part remains for the time being. What I was suggesting is, the notification they are challenging itself says that the verification would go up till 11th of April 2025. Matter is fixed on 8th of April 2025. By that time, we are required to file our affidavit in opposition in all the matters. Anything regarding this also we will file before 8th of April 2025. Matter is taken up on 8th of April 2025. If Lordship feels that before 11th, we should also give them an opportunity of having the
verification.
They have applied. There is no difficulty on that. Lordship gives an order on 8th, we'll verify it before the 11th or we'll extend it if necessary. Today, there is no urgency that we should now publish fresh notifications allowing them to come in.
No, I'm sorry.
There's nothing like that.
What the recruitment the process would
The
be?
process is they apply.
Including your written examination.
No, there's no written examination. Especially
Kindly have that notification.
What happens is, please, for a moment,
Yes,
Rishi, I was stopped when I was answering. I would request an audience. Now, my lord, what happens is they apply, there is a verification of all the documents. Their results we are not supposed to declare by orders of this honorable court. So the participation in so far as their merit is being concerned, that has already been given to them for the orders of this honorable court. Let the matter come up on the 8th of April. Or else you can thrash out the whole matter itself.
So I'm asking whether it will be consist of written exam also?
Nothing. There is no written examination. The marks obtained by them in different in all the different tests, they are taken into account. A total is done. The documents are verified. Then the final merit list is prepared. That part has not come till now. It is only the document verification we are
That's why I'm asking. After the verification, will there be a written examination?
No. Based on the marks obtained by them in the different
Under which rule you are?
under 1977 rules.
It's only based on the marks and
nothing else. So they have submitted their documents. Records are with us. As of today, allowing them
submitted.
Yes.
All of us have given us application.
In fact, whatever this, after the submission only this notice was issued.
Yes, the notice was issued 2 days back. So therefore, what I wanted to
I do not even have
Notice. It is
kindly have the IAA, the
2nd of January,
That is-
2024.
2nd of January is disqualifying me. Then is the Honorable Supreme Court's order. Now the notice has come up 2 days back where they are having verification for the regular candidate. That, my lord, will file in the IA 838 of 25, which I have filed and mentioned today, IA 838 of 2025. And the relevant page number is 35. 35.
335.
35. Only 35. Relevant page is 35. Annexure 1. If my lord would kindly have the date.
35. IA
IA is 838 of 2025. Sorry.
836.
If item number 2, there is an IA, which is 838 of 2025.
Yes.
My lord would kindly have the date on top, which is 18th March 25.
Yes.
And then this is the day when the matter was listed and they sought an adjournment. I am just reading the relevant part. It is for information to all the concerned that physical documents verification of the candidates who have successfully submitted their online application and uploaded the relevant documents in support of their candidature against the advertisement white so-and-so, which we just read, for recruitment of post of regular teachers in so-and-so under so-and-so. Date is given from 20th March to 11th.
Okay.
So they have not included us here.
It's okay. This is first phase. This should be first phase up
Yes.
to 11th of April.
And they have not included us here. The point that I am trying to make is, my lord,
Is there any order by this court while moving the writ petition that you should also be allowed?
yes, sir. It is here. It is included.
No,
I have the IA.
No, the division bench orders.
Number 1913.
There is an order of this court, not just this honorable court, but the division bench also, which says that we should be included in the participation.
With the order of your yeah, my
Can you just take out the other IE 836 of 25, which is an item 1. IE 836 of 25. Please take out page 67. 67. Page 67 is an order of 9th February 24. Lord, would kindly see the order of the Honorable Division Bench.
This one?
This is 9th February 24.
No, 0905/2024.
This is the one. In item number 1, yes, we have just taken out, Lord. Having heard the learned counsel for the parties for quite some time, we deem it appropriate to direct the state to provisionally allow the appellants to apply in the recruitment process initiated by advertisement dated so-and-so, provided that such application is filed offline before the last date, which was duly done. However, the final result of the appellant shall not be declared without leave of the court. Then please see page 86 also for a minute after this. Then that 3rd May order which my lord was referring to. First is an interim order and then the final order is 3rd May. And this was disposed of, making the interim order absolute, if I may read with my lord kind permission.
So in this, you have been only allowed to submit your application.
Indeed, my lords. And this verification is a part of that. The question that I put to myself today is,
State to provisionally allow the appellant to apply in the recruitment process initiated by advertisement.
indeed, my lord. So therefore, the point that I am trying to urge,
And
then at page, I'm sorry,
order of it will be for the first page only.
first
So up
phase.
to April to 11.
Yes, and the answer.
Second page will be notified. Your name will be.
There is one point there, my lord. In this first phase, none of us have been included. So the only question that I put to myself is that what stops the state from including us in the verification? I am not even asking for appointment today. The appointment, of course,
The
will be
question
subject.
of weapon doesn't arise.
Yes, so therefore, all
Your
that I
eligibility is under question, under challenge,
today,
question.
today the Honorable Supreme Court has settled that. Therefore, I was showing that Uttarakhand's order.
It's only